You can draft an airtight legal argument. You can marshal unassailable evidence. But if your document reaches the court's docket 1 minute past a strict statutory deadline or is misrouted to the wrong recipient, your client is locked out of the judicial system. The merits of your case are rendered entirely worthless. The 2019 amendments to the Rules of Civil Procedure updated the courts for the digital age, expanding electronic filing and service. This modernization introduced technical requirements that trigger an automatic default if a practitioner fails to adhere to the new standards. To navigate this machinery, we are executing a complete sequential forensic audit of Rule 13, analyzing the strict protocols from Section 1 through Section 19. Rule 13 governs the filing and service of pleadings, judgments, and other papers. It acts as the central nervous system of civil litigation, regulating exactly how information flows from the parties to the judge and from the parties to each other. Filing and service ensure that the court and all parties possess a synchronized record of the litigation. Without this specific compliance, even the strongest claims are vulnerable to dismissal for lack of notice or failure to meet the reglementary periods. Section 1 establishes the default mechanism for all pleadings submitted after monial complaint. We summarize this with the FSD mnemonic: filing, service, default rule. If you produce a document, you must file it with the court and serve it to the adversary. There is a specific exception built into Section 1. If a different rule prescribes a specific mode of delivery, Rule 13 does not apply. The initial complaint, which requires the court to acquire jurisdiction over a defendant, requires the service of summons. That process is governed by Rule 14. Section 2 clarifies the functional split between these two acts. Filing is the submission of a paper to the court. Service is the act of providing a copy to your adversary. They are distinct actions with different legal requirements. Under Section 2, service must be made strictly upon the counsel of record, not the client. If represented by several lawyers, the opposing side provides a single copy to the lead counsel. Notice to the client is not notice in law. Section 4 dictates the exhaustive scope of documents. Using the mnemonic JROPMAN, this includes every judgment, resolution, order, pleading, motion, appearance, and notice. The phrase pleading subsequent to the complaint is significant. It reinforces that the original complaint is handled differently, while every subsequent exchange is tied to these specific protocols. By requiring every paper that influences the litigation to be placed on the court's record and disclosed to the opposing side, these sections eliminate secret maneuvers and maintain the integrity of the judicial process. Sections 3 and 5 define the valid modes of delivery. For filing, the options are personal, registered mail, accredited courier, or electronic, the PRACE modes. For service, the PRACE FI rule adds facsimile and international conventions. For registered mail or accredited courier, the date of mailing is the date of filing, even if court processing takes weeks. But ordinary mail is not a valid filing mode. The court recognizes its date of actual receipt, risking a late filing. Section 6 governs personal service using the DOR hierarchy. You can deliver it directly to the party or counsel, leave it at their office with a clerk, or if the office is closed or unknown, leave it at their residence. Delivery to a residence is strictly limited to the window between 8 a.m. and 6 p.m. It must be left with a person of sufficient age and discretion residing there. Delivery outside these hours renders the personal service invalid. For service by mail, registered mail requires strict compliance with the SAP elements: a sealed envelope, plainly addressed, postage prepaid, and specific instructions. Ordinary mail is a fallback option. It is only permissible if no registry service exists in the locality of both the sender and the addressee. If a litigant or their counsel cannot be found, thwarting both personal and mail service, the system utilizes substituted service. This requires meeting the UDP requirements: prove the address is unknown, deliver the copy to the clerk, and provide proof of prior failure. The moment you hand that document to the clerk of court, the substituted service is complete. By defining these delivery hierarchies, Rule 13 ensures that evasive tactics do not stall the litigation. Sections 9 through 12 formalize digital litigation. Under Section 9, electronic service, like email or fax, is governed by the ECO rule. It requires either consent or an order. Emailing a pleading without prior documented consent or a court order makes the service entirely void. Section 10 introduces presumptive service, designed for instances where a party fails to appear for a hearing and later claims they never received notice. If court records show a notice was mailed 20 days prior for an addressee inside the judicial region or 30 days outside, the law presumes service. The court can proceed with the hearing even without the physical return card. Section 11 imposes a specific burden on the practitioner. If a lawyer changes their email address, they must file a formal notice with the court within 5 calendar days. Service to the old address remains valid until this notice is filed. Section 12 mandates strict SNAR formatting for electronic submissions. The subject line must explicitly state the party serving the paper, the nature of the paper, the party against whom relief is sought, and the specific relief requested. The 2019 amendments offer digital efficiency, but they transfer the burden of maintaining accurate contact information and formatting entirely to the lawyer. Some documents remain restricted to physical delivery. Section 13 governs the service of judgments, final orders, or resolutions. Because a final judgment triggers strict periods for appeal, it generally cannot be served electronically. This prevents disputes over server errors. Courier delivery is possible, but requires an ex parte motion and payment by the requesting party. If a defendant was originally summoned by publication and failed to appear, the judgment against them must also be published. Section 14 lists the documents that require conventional service. These are papers deemed too sensitive or bulky for electronic filing. Unless express permission is granted by the court, you must physically file initiatory pleadings, subpoena, sealed or confidential records, and exhibits that are not readily amenable to electronic scanning. Section 15 defines completeness of service, the moment the court considers the adversary officially notified, which starts the clock for their response. Personal service is complete upon actual delivery. Ordinary mail is complete 10 days after mailing. Registered mail is complete upon actual receipt or 5 days after the first notice from the postmaster. By isolating judgments and sensitive records from electronic modes, the law maintains a verifiable physical record for the most consequential stages of a case. Procedural compliance requires proof. Sections 16 and 17 detail how to substantiate filing and service to the court. For personal filing, proof is the date and hour endorsed on the original paper by the clerk of court. For registered mail service, you must present the registry receipt and an affidavit from the sender. For electronic filing, an affidavit of service is required, but it must be accompanied by a copy of the electronic acknowledgement of filing generated by the court. When serving via registered mail, the sender must file the registry return card with the court immediately upon its receipt to complete the record. Section 18 covers the issuance of documents from the court itself. While parties are limited in how they serve final judgments, the court has broad authority to electronically serve interlocutory orders and other documents to all parties. Section 19 provides a mechanism for property protection, the notice of lis pendens. In actions affecting the title or possession of real property, recording this notice in the Registry of Deeds provides constructive notice to third parties. Any purchaser of the property after this filing is legally bound by the outcome of the action. To maintain a claim, a practitioner must produce the exact evidentiary artifact required by these rules. Without the correct affidavit, receipt, or endorsement, the act of filing or service remains unproven. When these 19 sections operate in sequence, the flow of information between the court and the litigants remains uninterrupted and legally verifiable. Rule 13 is a strictly engineered system designed to balance the speed of digital communication with the fundamental requirement of providing notice to all parties. The 2019 amendments utilize electronic communication and courier networks to modernize the process, while retaining physical delivery requirements for the most consequential documents. Adherence to these filing and service rules is the prerequisite to having a case heard on its merits. A mastery of substantive law is required to win arguments, but a master-level execution of Rule 13 is exactly what keeps you in the courtroom to make them.